Okay, I came back. What? So, actually, you might repeat with lunch, early lunch or the. We'll continue about our topic. Actually, one other important scheme about this concern is what actually now a standing rule developed of long decades by Congress and United federal courts. You consider the concept, the negotiated rulemaking. What is that? Actually, the area is quite blurred, you consider, and ambiguous about any indispensable commitment. What is. So the area is left vastly for formulation of a judicial policy and executive response about practice and others, and their interaction with Congress. So we might hypothesize, perhaps true through the knowledge of a public policy and law. There are levels of concern about legitimacy of public agency rulemaking. You once introduced about a on-record requirement stipulated by APA, American Administrative Procedure Act, and that concept was not upheld in any absolute terms by Congress, by Supreme Court. Although it was pronounced that is discretionary. It might change on a case-by-case basis, and the specific statute might require to leave it on record. Then they would get better to undertake the procedure about to leave evidence and any documentary document tangible to support their action or decision. Nonetheless, the procedure may be waived despite this command. What actually one other concept would be a notice command requirement. You have been were instructed so that is simple and quite concise process to make the course of a conduct in compliance with the APA or the negotiated rulemaking may be placed somewhere in between the adversarial proceedings and stern requirement. Spelled out in the case or Matthews, or what is Matthews doctrine, and also the global principle about due process of law concept. So I have illustrated the science and information-based rulemaking and the ways, and the experts and career bureaucrats would be responsive with that concept and presumption. The basic idea is predicated on the distinct presumption of public agencies and bureaucracies, and how to interact with political demand, as exemplified in the last class. I have that is not, of course, the matter, but a public agency and non-profits and civic engagement was illustrated. By the same token, we have also another initiative. What you might see marriage initiative now exercised as a policy option to address the crisis of familial structure. We once have launched the kind of a financial benefit to facilitate the birth of children and others. So the structure of a demographic trend in the Korean community would see quite diminished in progress. So we know, and also consider the divorce rate, which increased in steady fashion. Actually imposed some policy challenges about the constitution of our community. Korea and United States has same concern, and that premise might be not irrelevant with a reduction of poverty. Poverty often be even with the kind of a marriage failure, divorce and other. And the empirical research has vindicated the same is not incorrect. You consider the marriage initiative has been proved to turn a positive impact on the reduction of a decrease of a divorce rate, and the poverty may be prevented in some scale of impact from the marriage initiative. So the kind of ideas may be developed and enriched through the expertise of public agencies in that specific field. And so in other aspect of consideration, we have discussed the volume of rules made by public agency, and what is ill consequence against the public lives of American citizens. You consider, and often the weird points of public policy making has to be dealt in a more principled way. For example, I now make a point from the argument of a diver, who is diver, Colin Diver argues the rule should have three qualities you consider: a transparency, congruency, and simplicity. So the concept is to increase the compliance and is more effectiveness, the kind of efficacy to serve the public goals they have intended on. So without these qualities, the rules would go as not effective. Very, they might in some cases tumultuous situation about challenged by various stakeholders. So it, of course, might be prone to bring a abundance of litigation. And consider the three qualities: transparency, congruency, and simplicity. The idea is, of course, for example, might be viewed in other context of over inclusiveness and under inclusiveness. The dichotomy developed by court rules about this contention, and so actually the agencies need to be a practical awareness about its consequence and effect, and also in that elaboration, the public agency who write the rules and others may have to devote their time and effort to increase the ideas we now, so the kind of effectiveness, efficacy, and participation and science-based decision-making. And transparency is also one other ambit you consider notoriously in WTO organization. The transparency is the desired point of a public goodness that the industries have pursued in the interest. Of course, that is one ideal we now see in the rule of laws on international trade, and liberalization of trade is critically dependent on that rule. So we have the kind of many important principles, including transparency. You see anti-discrimination. That is one dogma, and trade liberalization in other contexts. And now the transparency, the rule of transparency in WTO has been negotiated as a principle which gets through the a package of a multilateral trade agreement you consider, and that has been bred in the public policy and administration. And two other concepts embedded since the birth of a GATT 1947 GATT Bretton Woods Conference. What does it outlay the foundation of an international economic regime? So the idea might well penetrate the WTO trade administration, and also you raised the concern, epitomized in the term a paragon of administrative opacity. That is another aspect about latitude and leniency, the kind of concerning the public agencies and in the process of rulemaking. So that is the evil point that the policymakers have to elaborate to reduce in their most extent. And that is we have dual sides of flip in one coin. So the idea is related with the kind of a constitutional structure about sheer preserve of the executive branch and others. Nonetheless, how to fill the and undertake to fill the insufficiency or void of any idealistic Polish alternatives. And also, what is that? For example, consider one statute which employs the term substantially needs and interests. That is actually not less susceptible of any definite and hard definition. So the difficulties and problems might be, even with this kind of attribute, often identified in policy, the paragon of administrative opacity. In counter-cases, we may consider, as I have frontiered, the negotiating rulemaking. So, how to substantiate the vacuum of many practical needs, and also a rule is congruent when it states what the law it implements intended, nothing more or nothing less. So excruciating detail would be expected to dispose. Nonetheless, over-inclusive rules also might have a corrosive effect on working relationship in the public sector and the posture of the private sector toward the program. Consider for a moment the inspectors responsible for enforcement of the budget of safety standards, handrails to words in every American workplace. What the OSHA example has been charted in the previous class. Many in the private sector derided the approach undertaken by OSHA to regulation. Those who were attempting to force the OSHA actually were attempting to force the compliance with it. So, what? Do you see the public rules would serve the intended goals? So, a significant variant on over-inclusiveness is what we might call over-specificity. And in diverse view, the last quality, simplicity, is achieved when relatively little information is needed to determine the applicability of law and compliance with it. Complexity is the threat to simplicity. So consider, for example, the tax code, which must be perplexing in your first assumption. Actually, true through the organizations, notwithstanding public or private, and what individuals you might face with in some cases about vexing questions to reduce your tax on succession of assets, and that is not a merely influential over individual. So the consequence would be serious if we see the enterprise forms. The large enterprises or forms would be relatively convenient since they have plenty of resources and might hire experts of tax to respond with their problems or issues. Consider in contrast the small businesses. They have no sufficient funds to hire outside experts on tax or others. The difficult rules would actually traverse the due course of business operations in some sense. A small business association in United States once expressed that concern. They found that 2/3 of small businesses faced moderate to substantial burdens from rules. The most frequently reported burdens were lack of clarity in what is required, frequent changes in rules, and information about compliance and cost. The inability of small businesses to benefit from the positive effects of scale found in large workforces contribute to a 2005 finding that the cost per employee to small firms was 45% higher than large firms. As I've stated, complexity can be a tactic of government in some aspect. For example, the rules governing eligibility for health care benefits and the federal Medicaid program was complex and laden with qualification that their effect, if not their intent, has been to make it easier for the government to find some basis on which to deny benefit. So the high chances would be shortage of a physical capacities. So we now also worry or have a concern and some fear from the depletion of electric funds to address the social benefits now managed by government. One Korean researcher work has identified explore the present status of a social benefit candidates in some local cities, and the reason to be rejected by the ministry officers, and we may have the kind of a tendency in development and evolution of a social benefit system. The government may endeavor to procure a space of decision, leeways of a final decision making about eligibility and others. And often in the process, the policy addresses might be granted about disloyalty and unkindness from the social workers. So complex they may be employed to address the needs of public agency, of public administration. That is inseparable to bring our common concern and attraction on that issue. Complex rules hurt the government as well. It may be no easier for government officials charged with implementation and enforcement to understand the complex rule than it is for those in the private sector who are supposed to be complying with. And so we have a dual aspect of production of rules and also some meditative process to implement the rules and public policy. In that progress, we also have witnessed the kind of a personnel practices on personnel affairs. It's high turnovers through the units and departments may vitiate the expertise to be bred in some specific field. So they would not be an Persian policy making officers in that specific field. So they have to be sanguine to begin from the bottom of that the demand were relevant with the specific units and departments. So the policy of personal affairs also be one variant in this area of interest. How common are these quality problems, the frustrate implementation, compliance, and enforcement of the rules written by the federal government? When they occur, what are the root causes? So the scholars often raise 2 points, 2 important causes: poor information and effectual rule writers. So I have now highlighted the limitations of information briefly. Stephen Breyer, Supreme Court Justice, and important thinkers on public administration have once commented. Actually, he perceived the 4 sources of information is quite interactive in shaping public policy making. So what is the first source in your expectation? Of course, the industry. The industry is quite useful source that the policy makers have to be attentive. You see. And what is others? The public agency and departments may manage in-house research offices, staffed with experts and concerned intellectuals. For example, what is that? Land and Brookings Institute, a land institution. It is outside organs from the government. In any case, in-house research of the Korean government and also Samsung and Hyundai are notorious to manage their think tank. So that would be one basin to be fostered by a research assistance. They provide quite adequate information about formulating a more consequential policy and the policy to serve the fairness and against arbitrariness. And what are others? The public agency may hire outside experts, source, but it may be difficult to find experts on the right subjects. And also, in your surmise, it is true that they can be expensive. And finally, there are public interest groups. So quite a good partner to interact to produce a more effective policy, which possess the political community of Korea. But the point in this case would be that they are predictable. They are often committed to their authentic beliefs and adherence to specific policy. For example, you will not per se the civil activist group of environmental interest about some contra policy. from with contract policy. They will not be easily persuaded. And the industry's most reliable source of information on its own process and products, in his viewpoint, Stephen Breyer. And Breyer also says the staff's in-house research offices as limited in what they know and can learn in time to help on specific rules. So in general, Breyer sees information shortcomings as a central and persistent problem, and concludes in technical areas the agency, to some extent, inevitably works in the dark. Those words are true today as they were when Justice Breyer wrote them. And the high turnover rates, as I stated, might be a factor to result in limitations of rulemakers. For example, the EPA put it in this way: implementation and enforcement issues raised by regulations are not consistently identified or addressed as part of the rulemaking process. Step writing, regulations are often not familiar enough with or do not have enough exposure to the types of facilities and industrial groups that they are trying to regulate. Some staff members lack field experience and exposure to industry that limits their ability to design regulations that both are understandable and work in the field. This is especially true given the high turnover rates. So this point of argument, this aspect of argument actually is not irrelevant with the rule. Now we consider a negotiated rulemaking. So you have, in some cases, the court would not impose any formal requirement on the procedure, and the public agency then been limited in its mandate about designing the procedure as legitimate and others. So you consider in that concern on the record requirement, on the road requirement, the rules formulated in two important cases about due processable concept, and a vast area left actually untouched about the manner and ways to respond. So in that vast area, we also consider the improvement about many points of our good, public good and actually democratic virtues. So now we return to the previous scene. Child abuse is one example you consider about liability of government. So one injustice in the Joshua case, lamented as a dictum, and his personal statement was incorporated into that for official court opinion, lamented the flavor of lyric, poor Joshua. So a judicial style in major legal traditions on the planet, quite exotic in some cases, actually comparative legal tradition course. And we might also suppose if the court now in responsibility about several might complete the official duties with some admonition or personal expression about the essences of cases. Actually, the common law judges have long stories told to expose the profile of cases comprehensively, as you will see. You will see the personal comment about poor Joshua. He was actually damaged with brain hemorrhage from child abuse, and the public officers, who is social worker in this case, responsible to supervise the household, would be cowardly in actually quite non-responsive, given the chances would be high about prevention orders. In that case, the court ruled that the government would not be liable about its damages. Of course, the victims might pursue any tort liability individually against the workers. Nonetheless, the court has not endorsed the justification of damages from the government. And also, the worst situation may be found in other cases. The divorce order from the court might attach some additional terms and conditions about divorce. They may stipulate the sum of installments to serve the need of a child fostering and others. And also, in some case, the court may require the police officers to supervise the divorced families. In one extreme case, the 3 children have been killed about inactiveness and reluctance to respond with the court order. And also the police officers were victimized through the gun shooting and others. So the consequences are serious through fatal deaths to others. Then in that case, could we seek any tort liability against that irresponsible public officer? The court still position as negative in the sense. So we see the next fact. Point and visualize what a Federal Tort Claims Act, showing the government. So the attorney now has featured in as to convince the effectiveness of a tort claims against the federal government. Against this, as we see a limited stance now be practiced according to the prevailing court policy. So that is one point to be lamented by Professor Harrington. So we now are in a democratic frame of a society. So we are sovereign, individual sovereign. Collectively may be seen in political terms. Nonetheless, still the question remains open about this area of concern, liability against the federal government. And we have some summary review about the concerned cases. Well, in United States versus Florida East Coast Railroad Company, decided in 1973, there was a case decided by the United States Supreme Court. It is a classic example to what established the pivot of a colors in this area. In this case, Congress had enlarged the scope of the Interstate Commerce Commission's authority to prescribe per-diem rate charges for the use of one company's freight car by another, thus giving an incentive to each company to use the cars more efficiently or to acquire more freight cars. The Commission, in passing the regulation, had allowed railroads 6 days to file statements of position on the matter. So the Interstate Commerce Commission, ICC, has progressed on some procedure, public procedure, perhaps in the stage to get a written submissions about their position and others, stakeholders involved in due process. In this case, the oral hearing was waived. So actually, one of important requirements was not afforded in creating a public policy to regulate the interest parties, the stakeholders. Nonetheless, the procedure has not been condemned merely based on the due process of law and or Administrative Procedure Act. So actually, the court referred to its decision in Biometric Investment Company versus State Board of Equalization. It is a classic case between legislative and adjudicative profiles of rulemaking. In the class of legislative rulemaking, the stringent standard of due process rule would not be imposed in any mandated terms. So in this case, court considered the issue as legislative rulemaking. The district court found that the Interstate Commerce Act required that the Interstate Commerce Commission act in accordance with Administrative Procedure Act, which required the parties would not be prejudiced by an agency's decision to receive all submissions of evidence in written form. So the court distinguished between administrative rulemaking and administrative adjudication. Since there had been no effort to single out a particular railroad, the court found the agency's action was of basically legislative type judgment as opposed to an adjudication which could entail due process hearing rights. And what is the next case? Or perhaps the passive restraint, what alternative airbag, was contended in the courtroom, and the National Highway Traffic Safety Administration rescinded regulations requiring either airbags or automatic seatbelts in new cars. The court held the arbitrary and capricious standard for reviewing agency actions applied to rescinding regulations, the same as to enacting regulations. In this case, you will have to know the differences between rescinding regulations and enacting regulations. And the court employs a very popular term, now consequential of a vast area of cases, arbitrary and capricious. These are important standard in metaphor to describe the kind of a extent and controversies what they presented by similar class of cases. The National Traffic and Motor Vehicle Safety Act of 1966 directs the National Highway Traffic Safety Administration to issue safety standards, saying they shall be practicable, shall meet the need for motor vehicle safety, and shall be stated in objective terms. So this type of specific enactment has now been charted in Compass. As you see, for example, the nuclear waste is one controversial issue, very prevalent in the discourse of a public law and public policy, and we also have some statutes specifically to address the need of a compensation. Radiation Compensation Act in the last perhaps decades have been arranged to facilitate the agendas and issues. And so that specific statute would complement the basic rules about Federal Tort Claims Act and others. And you will also consider in next class, perhaps, about National Resource Defense Council. It is a non-profit and public organization which is devoted to the mission of protection of environment. So their motto is, while federal agencies are free to grant additional procedural rights in the exercise of their discretion, reviewing courts are generally not free to impose them if the agencies have not chosen to grant them. So that is main holding from the case disputed between Vermont Yankee Nuclear Power Corp versus Natural Resource Defense Council. And what actually their cause is quite extended over the environmental controversies in the United States. So, in the case about NHTSA, The Motor Vehicles and School Bus Safety Amendments of 1984 disallowed ignition interlocks and required restraint system other than seatbelts to be approved by congressional resolution before going into effect. Perhaps the policy of deregulation from Reagan administration might influence, how do you suppose? In any case, NHTSA justified this rescission by saying that there was no longer sufficient evidence for the efficacy of the regulations. This was not due not to change in judgment about technology, but due to change in car manufacturer plans. Whereas NHTSA originally estimated that 40% of new cars would have automatic seatbelts, it turned out that 99% of the car would use them. In addition, they were going to use a detachable type of automobile automatic seatbelt, which could easily be detached, at which point they would operate like normal seatbelts. The NHTSA also worried that a change would be expensive and would soar the public views towards safety regulations as was seen as wasteful, imposing example of a bureaucratic overreach. So from various reasons, NHTSA rescinded the regulations that have what actually is seen to disrupt the due expectations of industry and others in the COP viewpoint. And that is the point to actually in terms of predictability and legal stability, just white writing for the majority disagreed with this circuit and how the scope of judicial review was the same for rescission as it is for enacting regulation in the first place. So how do you assess the efficacy of government in the period of a small government, the legal liberalization, deregulation? The head counts of public officers in bureaucracy or others would be one good indicator about the effectiveness and efficacy of government. So they may execute a massive layoffs in some cases, and deregulation was pursued to facilitate the businesses. Nonetheless, this example, rescission of a previous regulation was struck down by the court. And the court also rejected the view the congressional action after the enactment of the National Traffic and Motor Vehicle Safety Act affected the standard of review, even if congressional action can inform the court's interpretation of the statute. So Motor Vehicles versus State Farm is notable for laying out the Supreme Court's interpretation of arbitrary and capricious review, also known as Harlow review, as set out by Administrative Procedure Act. It will be advised to review from the paragraph from APA and Allen versus United States decided in last century. Also, this is our concern. Same name of case might be identified in your search. One case decided in 1896. It might be more famous in some sense about this jury system. Prevention against hung jury in that time is very demanding as a public issue. And Allen charge, dynamic charge, hammer charge, you may see some famous text of Ellen Charles, and the case incurred a profound consequence of various jurisdictions in the United States, state courts, Alaska area. And you will see a case titled Descheny versus Winnebago County Department of Social Services, misspelled, must be not science, social services. In this case, the Seventh Circuit Court decision to uphold the District Court dismissal in summary judgment was affirmed. A state or county agency does not have an obligation on due process clause of 14th Amendment to prevent child abuse when the child is in parental, not agency custody, and the state did not create danger of abuse or increase the child's vulnerability to abuse. A failure to prevent child abuse by a custodial parent does not violate the child's rights to liberty for the purposes of the 14th Amendment. So, take a moment to read through the 14th Amendment. That passage, of course, is pertinent to the core logic. So it is framed, for example, to cover a limited stance, the execution of a death penalty, intrinsic court function to deprive the interest and property right, imprisonment, any coercive action to impose to detriment and a deprivation of a natural rights. The context raised in this class is not in that attribute. Actually, the affirmative duty would be more prevailing in sense. In that case, how do you see a persuasion to impose a stringent standard about compliance of public officers? Are you thinking to impose that requirement? Of course, we have a dissenting opinion from this majority court opinion. In that case, one Supreme Court justice lamented about poor Josiah. Poor Josiah, victim of repeated attacks by an irresponsible, bullying, cowardly, and intemperate father, abandoned by respondents who placed him in a dangerous predicament, who knew or learned what was going on, yet did essentially nothing except, as the court revealingly observed, at 193, dutifully recorded these instances in their files. It is a sad commentary upon American life and constitutional principles, so full of late of a patriotic fervor and proud proclamations about liberty and justice for all, that this child, Josiah's destiny, now is assigned to live out the remainder of his life profoundly retarded. Josiah and his murder, as petitioners here deserve, but now are denied by this court. So, how we appeal your sensibility about the person, what kind of lyric, in same or similar flavor with from the Voltaire's and others. It's interesting. And also in County of Sacramento versus Lewis, The case concerned high-speed chase between Sacramento County Sheriff's deputies and two men on a motor vehicle. Brian Willard driving and Philip Lewis as passenger. The chase moved in and out of moving traffic and reached speeds up to 100 miles an hour, ending when Willard lost control and the bike tipped over. One of the deputies could stop in time and hit Lewis, killing him. Lewis' parents sued the county sheriff's department, accusing the deputy of depriving Lewis of his 14th Amendment due process right to life through deliberate and reckless conduct. The district court ruled in favor of the deputy. The Ninth Circuit Appeals Court reversed, and then the Supreme Court ruled unanimously in the department's favor. So this might be available vastly in many Hollywood films, picture. And of course, how do you assess this situation when you are now in responsibility to determine the total liability of state? Do you actually are positive to look into details of a situation from it might be percent negligent in some cases and might raise difficult questions of law, including the tort series and the basic rules. Still, that ways of approach would not be openly endorsed by court. So the idea would be a subtle difference about, although it is shrouded with the tort claims. So the other party is government, as you see. In this case, the deliberate indifference accusation does not make sense, since in a high-speed chase, there is no time for deliberation. In determining what is egregious action, one should consider whether such action shocks the conscience. How do you connote this etymology? Shock the conscience. Might be minded sensed with obnoxious attitude of a public officer, perhaps arrogant to suppress the victims in one sense. It is necessary to serve the public peace and others in others. And also one point about individualistic scheme of total liability, quite complicated to reach the final conclusion. Okay, the rest of case and other issues would be left for further deliberation in next class. Thank you for your attention. So I now stop here. And as reminded, you will notice the posting about the final exam, and the questions were made open for your preparation work. And good luck on the final exam, and have a good summer vacation. This class would be projected through the 14th weeks in plan, so we have another class in the next week. Okay, see you.